Happy Republic Day 2023. Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. In this video, we are going to discuss a couple of case laws in professional ethics. The topic is right of the foreign advocates and foreign law firms to practice in India. In other words, whether the foreign lawyers can practice law in India or not. The simple answer is no. But the Supreme Court has framed a via media method called as fly in and fly out. We will discuss the details, that's all. Now, you all know, as per section 24 of the Advocates Act 1961, a person is fit for enrollment as an advocate if he is a citizen of India. Section 24. If he is a citizen of India, the other clauses are not that much necessary. Only an Indian citizen can practice law. At the same time, if there is any reciprocatory arrangement, that means if our advocates are enrolled in England, yes, we are going to allow the English people also to practice in India. Only in those two countries, the nationals of other country will be allowed. Right? So, who is a foreigner? Foreigner means not a citizen of India, not a national of India. Then how can he practice in India? No. So this is the answer. As per section 24, only Indian citizens or the reciprocatory country nationals, they are authorized to practice in India. But we have to admit the fact that India is becoming, entire world is becoming a global village. Foreign direct investments are there. Microsoft, Google, all of them, they have established their offices in India or other countries also. They are called MNCs, that is multinational companies. What is a multinational company? Multinational company is a company whose headquarters is located in one country and their activities or sphere of operation or other branches are located in so many other countries of the world. They will be guided by their law. Of course, it is a fact that they have to abide by the local law also. So normally, these multinational companies, they will be having their own advocate, their own law firms, their own suggestors. Then, when any case is filed against them, is it not their duty to come to India and defend them? So, therefore, thinking in a broad perspective, the government of India, before 2006, they wanted to allow the foreign professionals, particularly the advocates, to come to India and practice. Learning this, the Bar Council of India, which is the apex body for the regulation of advocates in India, they passed a resolution number 17 by 2006 on 12/2/2006, requesting the government of India not to give permission, not to open up the legal practice for the foreign lawyers. Because our law is different from their law. They wanted to have a dialogue with their counterparts in other countries also. Anyway, this is the origin where the legal practice by foreign advocates is not allowed by the Bar Council of India, which is the apex body for the advocates. Later, in the year, first discussed 2010. So, maybe in the year 1993 or so, the foreign law firms, very famous foreign law firms, they have written a letter or they requested permission from the Reserve Bank of India under Foreign Regulation Act, Foreign Exchange Maintenance Act, to grant them permission to open offices in Bombay and other places. The RBI agreed. The RBI said yes. Of course, clearly, the RBI has given a condition that this is only for allowing them to transfer the currency from India to other countries to India. That's not. But not in the legal profession. They will not involve in the legal profession. That means the standards, the qualifications, all these things they have to look after by the body, that is Bar Council of India only. Right? So against this also lot of resentment was there. Therefore, an organization, an NGO I can say, called as Lawyers Collective, that means group of lawyers, Lawyers Collective, they have filed a writ petition in the shape of public interest litigation regarding the RBI permission. Yes, the RBI should not have given permission. So this you can read as Lawyers Collective versus Bar Council of India 2010. So even though RBI gave permission, Bombay High Court rightly said no, legal profession is not a business. So they cannot collect money and the transactions cannot be allowed. Therefore, they are not allowed to establish their offices in India. Right. More than that, better you remember the Vodafone case is very important case. Vodafone International Holdings versus Union of India and others 2012. There it is very clearly stated that legal practice includes chamber practice also. So the lawyer need not go to the court of law even if he gives suggestions, even if he gives opinions, even if he drafts the pleadings, even if he prepares the written documents. All this is called as also legal practice. So foreign advocates, no. And we are coming to the most important case. This is A.K. Balaji versus Union of India 2012. Here, so this is a very important celebrated case where the topic of the foreign lawyers coming and practice in India is highly deprecated. Even the Supreme Court also has to interfere. Ultimately, please remember, Supreme Court proposed the so-called present procedure of fly in and fly out. The foreign advocates, they cannot establish offices in India, but they can come to India, suggest or give suggestions or give advice to the local advocates who will file on their behalf. They have to fly in and fly out, but they cannot establish their offices. So to conclude, I want to tell you, the foreign advocates, they can come in and go out, fly in and fly out, but they cannot establish offices. They cannot practice in the Indian courts. So this much you have to learn, and I think you may get a question on this topic also. Better you get prepared and answer the question by citing these three case laws like Vodafone case, A.K. Balaji case, and ultimately Lawyers Collective case. With this, I am concluding. Thank you very much.